Hello, my name is Donald K. Scott. I'm one of the attorneys at Hochman Plunkett. The workers' compensation topic I would like to discuss today is occupational disease. A workers' compensation claim can occur based on an injury or by what is referred to as an occupational disease. I think the concept of what an injury is probably pretty clear to everyone. That would be, for example, bending over to pick up a heavy item at work and feeling a pain in your low back, and the result is a lumbar strain or a herniated disc in the low back. That's very understandable, and most people can readily understand that and comprehend what that means. But what is an occupational disease? Because that also would entitle an injured worker to participate in the workers' compensation system. An occupational disease is when an exposure to a hazardous substance at work produces a harmful effect on the worker, and it results in a diagnosis of a medical condition. The condition can be very serious. There are several listed occupational diseases in the Ohio Workers' Compensation Statute. Some of these, for example, when there is an exposure to asbestos in the workplace, can lead to a condition called asbestosis. It can also be coal miners' pneumoconiosis. There can be anthrax. There can be a radiation illness. Firefighters who develop cancer can be permitted to participate in the workers' compensation system for that cancer. There can also be cardiovascular, pulmonary, or respiratory diseases for firefighters or police officers, and that would allow them to participate in the system. Those are listed in the workers' compensation system as conditions that will allow participation in the system. There are also unlisted conditions that can be occupational diseases, and the unlisted ones are conditions that result from a risk that the employment duties create that exceeds the type of risk that the general public would be exposed to, and it creates a hazard that the employment duties create that is in excess of what the general population would experience in their normal day-to-day activities. A perfect example of this type of an occupational disease would be the condition of carpal tunnel syndrome, which is produced by repetitive, forceful use of the hands and wrists in the workplace. Now, any occupational disease does require medical proof to establish that it exists. And if an occupational disease that results from employment is established, the result can be that the injured worker can receive medical treatment and compensation. Those would be available once the condition is established to have been produced at work. If you have a question about an occupational disease, or if you believe that you may have an occupational disease, I would urge you to discuss that with an attorney, or if you have any question about a workers' compensation claim, you should contact an attorney to discuss it.